Welcome everybody. This is the MAREI PartnerCast. This is our third one we've done this year. It's a semi-irregular virtual event from Mid-America Association of Real Estate Investors. I'm your host, Kim Tucker, the director at MAREI. We are recording this and we will be providing the PowerPoint to everybody that's on the webinar call today so that, if you miss a certain little segment, you don't have to write it all down or take a screenshot. We'll be sending you the PowerPoint. I highly recommend to have a notepad so that you can jot down highlights of any action items you need to implement or research further. And lastly, we're going to ask that if you have questions to post them in the chat box, and we will, if it's a key point that we need to cover right now, I will stop Julie and ask the question. Otherwise, we'll take all the questions at the end. And I kind of wanted to share what got us. Probably in January, I saw this post. It was a demand letter from the Kansas Real Estate Commission to a new wholesaler that was working on his very first wholesale, according to him, and he posted it on Craigslist. And then he had gotten this long letter from the commission demanding to know all kinds of things. And then when we had an ensuing discussion of that on Facebook, I found that quite a few people didn't think that the real estate law applied to them if they weren't a realtor. And then I had several conversations with some of the more prominent wholesalers in town, and they said they had sat down with Julie to find out what we need to do and what we can and can't do. So that's how we ended up calling Julie Anderson. So let's give a little bit more about Julie. You can see her name and her website on the screen there. It's Julie Anderson with Anderson and Associates. Her website is mokslaw.com. I highly recommend you check out her website, especially if you are a landlord. She has a ton of resources there for you that you can just download for free. She is our go-to for all things landlord-tenant, and she's well-versed in most things real estate. But today we're here to talk about wholesaling and real estate law. So I'm going to welcome you to the call, Julie, and let you take it away.
Thank you, Kim. I appreciate the introduction. Again, my name is Julie Anderson. I am the owner and managing partner at Anderson and Associates. We are a law firm that concentrates its practice in both Missouri and Kansas in landlord-tenant law, debt collection, foreclosures, and creditor-related litigation. I've represented multiple Missouri and Kansas wholesaling investors in both Attorney General and Real Estate Commission complaints. I've probably spent, countless hours also reviewing and drafting real estate and assignment contracts and dealing with title companies when these contracts go amok. So when asked what I do for a living, I almost always say that I'm in the business of keeping real estate investors in business, and that's really why we're here today. So I'm going to be covering what is wholesaling, why is it so popular, why does it have such a bad rap, what are some of the risks of wholesaling. We're going to get into the statutes in both Kansas and Missouri. I'm going to guide you on what to do if you get a letter like the one that Kim described from an Attorney General or the Real Estate Commission, and some of the best practices for wholesalers. I'm going to be going through an ideal contract and an assignment contract, in my opinion, kind of in the form of a checklist. So if you're using these types of contracts, you can take my checklist back to your documents and see your strengths and your weaknesses. We're going to talk to maybe some alternatives if wholesaling is just too risky, or and some common myths. So I've gotten onto some of your blogs and questions and taken from those some of the myths about wholesaling. And I'm going to do my best to make sure that there's sufficient time at the end so that you can ask questions. I currently don't have a lot of information about wholesaling on my website. I may be adding some additional information in the upcoming weeks since I've been spending some additional time getting ready for today. I think some of these resources would be great on the website. Our website is MO for Missouri, KS for Kansas, LAW for the law.com. And under the form tab, I have numerous forms that are there in Word format and free for members of MAREI and the public to use. It's always been my theory that if you have great notices and access to them for free, that you'll use those rather than just downloading things from the internet. which I'm not a big fan of. So let's get started. What is wholesaling? So real estate wholesaling occurs when a party, known as a wholesaler, contracts with a homeowner, who we call a seller, to purchase a property. The wholesaler then markets the property to potential end buyers and assigns the contract to one of them. The wholesaler quickly makes a profit without ever owning the house, and the profit is calculated as the difference between the contracted price with the seller and the amount paid by the end buyer. That fee that you are paid as a wholesaler is that difference. And the goal in real estate wholesaling is pretty much to sell the contract before the contract with the seller closes, so that you're not stuck in the contract as the buyer, and to make a profit as quickly as possible without ever owning the house or expending capital. It's a pretty simple principle of profitability. You want to buy low, or essentially contract low, and then sell high. So that essentially is just the nuts and bolts of what wholesaling really is. And why is it so popular? So there's a lot of online blogs. Over the last probably 2 years, wholesaling's been getting kind of a big buzz. And the reasons why it's so popular are there's no perceived need for a financial investment. So you don't really have to have hardly any money. The wholesaler never owns the house and invests only in earnest money deposit. So sometimes it can be as little as $5 to $100 investment. There's a pretty fast cash return. So you're turning these transactions in less than 2 months. I think the typical is about 45 to 60 days until you've located the property and you're making a profit. There's no renovation or carrying costs because you don't own the property. There's no repairs that you have to make to the house. And a good credit score is really not necessary. You don't need a loan, and you don't need much required capital at all other than that earnest money deposit. And you can avoid all the hassle of rental property management and maintenance and just the headaches of ownership. Why does wholesaling have such a bad rap? Well, there are several reasons. The first is that wholesalers are perceived to be acting like unlicensed real estate agents. We're going to get into the nuts and bolts of this, but from just the large perspective here, wholesaling is essentially acting like a real estate agent in that the wholesaler is brokering a real estate transaction between a buyer and a seller. So you're working with the seller to get a contract, you're getting that contract over to an end buyer. And many attorney general's offices are viewing that to be a type of brokerage action. There's always a risk of a civil lawsuit. So when I put this together, I just want people to know essentially the background of why wholesaling is criticized. On the civil side, so wholesalers risk being sued by sellers because the buyer never actually intends to buy the house, and many wholesalers will conceal that to the seller. They don't want the seller to know that they're planning on making this profit and selling it to somebody else. So the elements of civil fraud are, 1, a misrepresentation of a material fact. So the simple point is, hey, I'm going to buy your house. The second element is knowledge that the fact is untrue. The wholesaler does know that he can't or won't often buy that house himself. 3, an intent to mislead the victim. Well, your intent is pretty clear in the contract. I intend to buy your house, when you don't intend it, depending on how you draft these contracts. And the 4th is some sort of financial damage. So if a seller were to sue a wholesaler civilly, they'd have to show that they've been financially damaged by this misrepresentation by the wholesaler. For example, their contract didn't close, or it closed later, or they had to sell it less because they were under the pinch of time. There's a risk of criminal fraud charges. Again, attorney generals around the United States are considering these transactions to be quasi-fraudulent and sometimes truly intentionally fraudulent because the wholesaler is marketing a house for sale that isn't his. And I want to be very clear, if you're marketing the house for sale versus the contract for sale. And then wholesalers are entering into these contracts with the intent to never actually close. So just again, depending on what your contract says, it's pretty easy to find a kind of misrepresentation in these types of transactions. And the third is reputational damage. There are a lot of people getting angry at wholesalers. The first category of people that have been or are angry at wholesalers are sellers. So if you're going to tell a motivated seller by a contract that you're going to buy their house, and then you just turn around and say, I'm not going to buy your house, but someone else is, or worse, you just back out at the last minute because you never had the money to buy it in the beginning, sellers are angry. I mean, understandably so. Further, the entire goal of wholesaling is to get a contract for a very low price, which means that, well, really one of two things. The seller doesn't know any better. They don't know what their property, they don't know any better than to enter into this contract. So we're seeing some wholesalers around the country take advantage of disabled people, aged people, desperate people, or sellers that are just otherwise compromised, or the seller just has an inaccurate understanding of the value of their property. So overall, they're just unaware sellers or misinformed sellers potentially. And if they feel misled, again, they're angry. Angry brokers. This is probably the number one source of where we're seeing complaints. Other real estate agents and brokers, they feel like the wholesalers are kind of working around the system. So agents and brokers are in the business of making money on real estate transactions. They spend countless hours obtaining and maintaining their licenses, and wholesalers are just working around them, working around getting a license. And essentially wholesalers are taking business away from agents and brokers, and they feel like it's unfair, so they're making complaints. And angry end buyers. Sometimes wholesalers aren't very transparent with end buyers as to what their role is. End buyers can be kind of angry if the seller backs out. And if you try and conceal the sales price and try and conceal your profit from them, they feel, well, angry. So there is some reputational risk to wholesaling. And these are essentially the reasons why wholesaling is getting kind of a bad rap, around the country. What are the risks of wholesaling? Okay, so wholesalers don't have any guaranteed income. I would probably say that real estate investors generally don't have many guarantees, but there's really no steady income guaranteed. You're not going to gain any equity in any asset over time like you would if you would buy and hold and lease. And you're not going to get any steady paychecks. You're going to have to work pretty hard to find these end buyers and find these sellers and to put these transactions together without any, true guarantee. Probably the most common risk that I see is just deal failure. Wholesalers are more likely to have deals fall through than just general real estate contracts. In most cases, the sellers flake out, or they find out about the end buyer, and the end buyer will go around the wholesaler and just buy it for the price or slightly higher than what you as the wholesaler are going to buy it. And I get a number of phone calls, and we have filed lawsuits on behalf, I think just one that I can recall off the top of my head. There are some remedies for how we deal with this, but when we're just talking about risks, I think you should be aware if you're going to wholesale, there is a risk of deal failure. Then the risk of an attorney general investigation. These are probably the most serious, and I would say to take them most seriously if you receive a letter from the attorney general. So the Missouri Attorney General works to protect consumers, so sellers, and they want to ensure a fair marketplace by enforcing what's called the Missouri Merchandising Practices Act. And the Kansas Attorney General enforces the Kansas Consumer Protection Act. And there are these consumer protection acts essentially all over the country, in every state that I'm aware of. So by filing complaints, consumers let the Attorney General's offices know about unscrupulous businesses and individuals. And both offices rely on consumers to act as partners with the government in helping root out fraud and helping the government bring criminals and scammers essentially to justice. So this is a criminal type potentially criminal and sometimes civil investigation. Attorney generals are mediating complaints between businesses and consumers each year, and this process results in millions of dollars in restitution, exchanges of services, financial penalties, and just fulfillment of promises. Those are some of the remedies that we're seeing come out of the Attorney General offices. Kansas has not posted any of their numbers for 2018, but the Missouri Attorney General has. They received 116,912 complaints in 2018. Of those, 2,842 of those complaints fell into the category of retail and real estate wholesale. So it's difficult for me to pinpoint the exact numbers of Attorney General complaints regarding wholesalers, but I can definitely tell you, I mean, it's in the thousands annually. That doesn't necessarily mean the Attorney General will investigate, but these are the kinds of numbers. And I think you should be aware of the risk that if you falsify statements or mislead consumers, that if you're not careful about how you're doing these transactions, this is a true risk and does carry some potential criminal implications. And the most common, so again, the most serious risk would be an Attorney General investigation, but the most common risk is a real estate commission complaint. These complaints are being made by real estate agents and brokers who are, they have their britches in a bunch because you don't have a license and you're out there making money as a wholesaler, and they want those deals, so they think it's unfair. So both the Kansas and the Missouri Real Estate Commission have authority to take disciplinary action against agents and brokers, which is what most of us commonly think of what the real estate agent is doing. However, there are lots of cases involving unlicensed individuals in Kansas and Missouri. Those unlicensed cases in Kansas are referred to the Kansas Attorney General's Office for prosecution. And the reason I'm emphasizing this to you is that it's pretty important for you to know that the Kansas Real Estate Commission is not doing their own prosecution. They're sending it to the Attorney General's office, and it's important to know that because the Kansas Real Estate Commission is escalating these to more serious investigations because Kansas doesn't have the attorneys in their real estate commission to handle this kind of complaint. Cases involving unlicensed individuals in Missouri are usually sued by the legal department of the commission. And the truth is that they're understaffed. This is just my opinion. This is not a legal conclusion, but I think you're more likely to have investigations by the Attorney General in Kansas just because the Kansas Real Estate Commission doesn't have the authority to file a lawsuit. They have to escalate all these things up to the Attorney General to become more serious. Whereas in Missouri, we can kind of just resolve these amicably with the Real Estate Commission. So that's why you're probably hearing online more, as Kim indicated earlier, more complaints and things that are escalating faster in the state of Kansas. So again, we're going on with the risk, but I want to get into what is the actual law. So I put here in the PowerPoint the statutes if you want to look them up yourself. I'm going to be kind of going through them with you. But Kansas law says no person, that means no person present in the state of Kansas, can sell a property on behalf of another without a real estate license. And they should not negotiate a sale of real estate without a license, cannot assist or direct in procuring prospects calculated to result in a sale without a license, provide lists of real estate as being available for sale. And I really want to emphasize this, providing lists of real estate. So we're going to talk a little bit about your advertisements as a wholesaler, but you need to be very careful that you're not listing the real estate, that you're listing the contracts, not the real estate. And counsel for the Real Estate Commission have previously held that both selling an equitable interest in property is a licensed activity and paying a referral fee. A lot of times wholesalers are out there offering referral fees to people in order to procure end buyers. The Real Estate Commission has come down on these Kansas wholesalers for doing that. So you understand the risks. A willful violation of Kansas law is a misdemeanor, which is punishable by jail of not more than 12 months and a fine of not less than $100 or more than $1,000 for a first-time offense. So if you do these transactions incorrectly, you could be looking at jail time of not more than 1 year or a fine of not more than $1,000 for the first violation. Where I start to become concerned for people is that these penalties can just escalate criminally if you've had more than one previous violation. So the law in Missouri is relatively similar. It's stated a little bit differently, but the nuts and bolts of it are quite similar to what Kansas is. And I think we would see that this unlicensed real estate activity is similar throughout the country. So Missouri law provides it shall be unlawful for any person to act as a real estate broker without a license. The next statute goes on to define what is a real estate broker. So a real estate broker is any person who, for another person and for compensation, does one of the following: sells real estate on behalf of another person, negotiates or offers to negotiate the sale of real estate, lists real estate for sale, buys or deals in options in real estate, or advertises and holds himself out as a licensed real estate agent. It's really important when you're dealing with sellers as a wholesaler that you're very clear and your contracts are really clear as well, that you're not a licensed broker, you're not acting as a licensed broker. Or if a wholesaler assists or directs in the procuring of prospects that are likely to result in a sale. Under Missouri law, a violation of acting as a broker without a license could carry a Class B misdemeanor, up to 6 months in jail, and a fine of up to $1,000. So this is the law that we're drawing from. If you do these things wrong, these are the potential criminal risks to wholesalers. So what do you do if you get a letter from an attorney general or a real estate commission? These are my 4 top hits, or top tips, essentially. Don't ignore the letter. A lot of my clients ignore things, hope it'll go away, or they say, hey, this was sent to an address where that's not my updated address, so they think they can kind of run from the letter. Unfortunately, they'll find you. I mean, eventually they're going to find you, particularly if you're registered as an LLC, which I would like you to be. And so just don't ignore it because they sent it to the wrong address. Also, don't assume that if they point something out in the letter that you had posted on the internet. A lot of times wholesalers are getting caught because of advertisements that they posted on their websites, and so they take it down and then ignore the letter. News alert, things that are on the internet are there forever. Even if you take it down, they can still locate it. The government can find it on the internet. I mean, this is probably what we're all trying to teach our children about Facebook. It's pretty much there forever. My number 2 tip is pay close attention to the deadlines. In cases that I've negotiated with the Real Estate Commission and the Attorney General's offices, the longer we wait and the more missed deadlines that we have, the less likely an attorney can get success for you. A quick response, taking full responsibility, working with the Attorney General's offices or with the Real Estate Commission to correct any misleading statements is truly your best course of action. So if you receive a letter, don't ignore it and look at the deadline and meet that deadline. I think you should consult an attorney just because those of us that are working with wholesale investors, we can get you on the right track. A lot of times we're able to negotiate no criminal penalties, kind of just a deal where they say you did bad and we say we're sorry, and then you walk away without any penalty, particularly for the first violation. I don't know that on occasion when the wholesaler communicates on their own behalf, essentially pro se, they say things that an attorney would never advise you to say. And I just need to warn wholesalers that There could be jail time involved. There could be fines involved. So anything you say can and will be used against you. Really a good idea to go in there represented by an attorney if you receive one of these letters. So next we're going to go through what I think are the best practices and what these contracts should really look like. The key to wholesaling is to just really have transparent advertising and transparent contracting practices. So I've set this up sort of as a checklist for you. As you're going through your real estate purchase contract, if you're wholesaling, this is the one that you'll have with the seller. These are the things that I think it should contain. So one, let's just start out with, we should identify the type of the contract. Sometimes when you download things from the internet, it's very unclear. So I think you just at the very top start with, this is a residential sales contract. That's what it is. You need to name the seller and quote, his, her, its, theirs, heirs, devisees, administrators, executors, or legal representatives. That means that the seller dies during the term of the contract, that you could continue to enforce it against, their heirs. They're next in line. I'm going to identify 7 of these that I think are the most important. So this next one I consider to be one of the most important, and that is you need to state the wholesaler's name and or assigns, quote, and or assigns. And what that does is it puts the seller on notice that you may assign this contract. It's kind of our first introduction to the fact that this contract would be binding on your assigns. I want the effective date, which is usually the date of the last person to sign. You need to state the property address. I prefer that there's a legal description in these. I understand sometimes it's difficult, and we'll put, legal description to follow in title report. But if at all possible, legal description is a very good idea up front. The purchase price, and again, this next one is very important. I want you to outline the inspection contingency period. This is the number of days that the wholesaler has to inspect and accept the property or reject the property. This is the time period that the wholesaler has to find an end buyer. So really take into consideration, I know we want to turn profits quickly as wholesalers, but I want that time period to be long enough that you have sufficient time to find that end buyer, and outlined very clearly. Earnest money, this is a necessary element to a contract. It needs to be some form of compensation or currency, some amount of money. You'll see $1, $5, $100, $1,000. But some money needs to exchange hands. Most sellers in wholesale deals want to sell the property as is. Most buyers and end buyers understand that these are investment properties, not necessarily primary residences, although they could be, and that you're selling them, the seller's selling them as is. State the closing date and the possession time. And this next, warranty of title, put a little star by that. The seller must be able to give a warranty deed as opposed to a quitclaim deed. And the reason I say that is that if you're going to market these to an end buyer, the end buyer wants to get clean title. They want to buy something that's marketable. All my contracts have a risk of loss provision, and that means that if the property were to blow up or burn down or become uninhabitable or in worse condition than it is at the time you enter into the contract, that the seller has that risk until closing. The closing costs and attorney's fees should be, usually they're split, but I do see wholesalers sometimes pay for all of them when the seller's in a particularly bad position. That's one negotiating tool. You should outline rents, homeowners association dues, and taxes. They're usually prorated through the date of the sale. Sometimes wholesalers will agree to pay back taxes as part of the transaction, and again, to try and get the deal going. If so, you need to put it in the contract. And a duty to inform of the condition change. I like to put that on the seller, make sure that if something happens between the time the wholesaler enters into the contract and the time it closes, that the seller has to inform the buyer. Cancellation, put a star next to this. It's there at the bottom in the left column. It's really imperative that it's clearly written that the buyer can back out. The wholesaler can back out for any reason or no reason at all during the inspection contingency period. You know, as a wholesaler, if you do not have the ability to become the buyer, you really need to be clear in this contract that during that inspection contingency period, you have the right to back out if for some reason you cannot find an end buyer. So big star on that cancellation. Maintenance and casualty and loss. Again, I like any losses to stay with the seller until closing. I usually have a seller's disclosure section and a buyer's disclosure section. Under the seller's disclosure, I want to state the seller is bound by the contract. So the seller should warrant that she's authorized to enter into the contract. The seller should warrant that she has the capacity to enter into a contract. And the seller should warrant that she has free and clear title to the property and will convey marketable title at closing. Again, this is what the end buyer wants, is marketable title. Seller should warrant that she has insurance and will maintain it during the term of the contract. And the seller should warrant that she has the ability to close, meaning there's no mortgages, contracts, judgments that are negatively impacting her ability to do so. If so, the seller should disclose these. So I'm drafting this like it's the most perfect scenario we've ever seen. However, there's sometimes the seller cannot warrant these. But this is a starting point for what the wholesaler, the buyer, should be talking to the seller about. The seller should warrant that there are no known defects adversely affecting the value of the property, pending foreclosures, pending judgments, pending mortgages, no hazardous materials on the property, no judgments threatening the equity in the property, and no pending bankruptcies or contemplation of bankruptcy during the term of the contract. Again, some of the sellers won't be able to warrant this, but you need to talk about each of these elements with the seller so that you understand what kind of contract you're ultimately marketing to an end buyer. And then the buyer's disclosures should be that the buyer is going to warrant that he's authorized to enter into the contract and has capacity to enter into the contract. And then put a star by these next two. I want you to clearly state in these wholesale contracts that the buyer is acting as a principal in this transaction, not as an agent. If for some reason you are a licensed real estate agent or broker, you need to make a full disclosure and state that you are, but you're not representing the seller, that you're acting as a principal and not as a real estate agent under this contract. And the next one, probably the most important, if you're going to learn anything today, is you need to make a full disclosure of your intent to potentially assign this contract. You should state that you may or will, and I usually say may/will, assign the contract to an end buyer for a fee to be paid by the end buyer. You need to be really, really clear. And this can get you out of a good number of complaints by sellers. If you're clearly disclosing that you intend to assign this to an end buyer, how can a seller come back later and say that you misled them, that you were truly going to close and it wouldn't be an end buyer? I spell out what happens if each party defaults. So if a buyer defaults, then the earnest money that wholesaler buyer goes to the seller as the seller's sole remedy. So I try to really limit the remedies for the seller if for some reason the wholesaler cannot find an end buyer and cannot close. I'm a little more punitive in these contracts against sellers who default. I say that the buyer could specifically enforce the contract or may sue for damages and attorney's fees. So if I'm drafting the contract, it's particularly in favor of the wholesaler. And we find that in these disclosures and in this default provision. If the house was built before 1978, there needs to be a lead paint disclosure and a governing law provision. Please, I beg you, the state where the property is located is the governing law. If you're downloading these contracts from the internet and you find one in, I don't know, New York, California, don't say California law applies. creates a lot of problems if we ever have to enforce these contracts. I am allowing people to use electronic signatures as it is legal in both the state of Missouri and Kansas. I like, when dealing with more unsophisticated sellers, to have a pretty bold, capitalized contract disclosure where it says, please carefully read the terms herein before signing this. When signing it, when signed by all parties, this is a legally binding contract. If you do not understand, consult an attorney before signing. I think this just lends, again, to the more disclosure, the better on behalf of these wholesalers. And then both the seller and the wholesaler/buyer should sign the contract. The best practices for these assignment contracts. Most of my assignment contracts are very short. They essentially just say, it's an assignment contract. It identifies the assigner. It names the assignee. I usually do not give the assignee additional rights to further assign, so I just say the end buyer's name, not and/or assigns. These transactions can get pretty messy when it's double or triple assigned and wholesaled over wholesaled over wholesaled. So I usually say keep it pretty simple and don't allow that to be a possibility. The assignment contract should state the effective date, which is usually the date of the last person to sign. It should identify the date, the title of the underlying real estate agreement being assigned, and the identity of the seller. A number of my wholesalers don't want to provide a copy of the sales contract to the end buyer. I think they should. It's my best advice, and I think it's the best practice. But at a very minimum, you've got to disclose to the end buyer the identity of the seller, the address, and the terms that are important that they are purchasing, the property address, the legal description. Almost all contracts have some sort of declaration of assignment, meaning the buyer intends to assign and the end buyer intends to accept the assignment and be bound by the contract. The purchase price, this would be the purchase price under the contract plus the wholesaler's fee. We put it all into this assignment contract as a lump sum. I want the assignee, which is the end buyer, to assume all the duties of the buyer under the contract. There should be an additional earnest money deposit. And I want you to spell out the inspection contingency period. The goal of wholesaling is to provide the end buyer still with some term of time left under the original contract to inspect and accept or reject the property. I want the assignment contract to state the closing and possession dates. Again, the sale will be as is. That seller should provide the end buyer with a warranty deed. Mimic the language, particularly if you're not going to disclose the underlying contract. You need to mimic the language of the underlying contract that's being assigned as to what happens upon default, what kind of deed are they going to get, what kind of condition is the property. I put a default provision in these assignment contracts that say if the seller defaults, the end buyer can specifically enforce and sue for damages and attorney's fees. But if for some reason the end buyer defaults, that the end buyer agrees to pay the earnest money deposit to the buyer. And that essentially, if the end buyer backs out outside of that contingency period, the only money that the wholesaler is really going to get is that earnest money deposit. So I encourage my wholesalers to make that earnest money deposit as large as possible to cover the time and the inconvenience of finding the end buyer and then having them back out. I always put a little star by this. I always want some type of an indemnification and a hold harmless provision. And that just means that the end buyer is going to cover any liabilities of the wholesaler as to the transaction and is agreeing to that. Please, again, if you are going to download assignment contracts from the internet, make the law of the state where the real estate is located the law of the contract. It gets, again, very confusing if you're using out-of-state documents. And signature blocks. So I want the wholesaler, the buyer, and the end buyer to sign these. I sometimes also allow electronic signatures. They are authorized under both state laws. And the best practices for your advertisements. Advertisements are really where you're going to be investigated. You know, most attorney generals won't have a copy of your contract unless for some reason a seller has given it to them. They're going to just be getting complaints most frequently from real estate agents, and they're going to be examining your advertisements. So best advice I can give you is just be completely transparent that you're wholesaling, that you have an interest in the contract and not in the real estate. You do not want to get on MLS and cut and paste an advertisement that a real estate agent or broker might be using and then put yours on Craigslist or on your website. You need to be very, very transparent and careful that you're disclosing your interest and your role as the wholesaler in your advertisements, not just, here, look at all these great houses that are for sale. That's what real estate agents do. That's not what wholesalers do. You also need to provide disclosures to every party in your advertisement. So I usually draft at the bottom, if you've seen anything that's advertised by a client of mine, you know, this is a wholesale transaction. I am, you know, I have this interest in a contract and I'm looking to assign it to an end buyer for compensation. Just be honest. You don't want to ever sit in front of a real estate commission, in front of a judge, in front of an attorney general attorney, and have to read aloud your misleading advertisement. Also, always use equal size print for your disclosures on your websites, your emails, your LinkedIn. I don't want you to have all this flashy and great information about the house and then in a 4-point font that you're a wholesaler and you are not the seller. So just make everything the same font. I think it at least shows that you're not trying to hide something. Alternatives to wholesaling. I mean, this is kind of clear, but if it's such a great deal that you're brokering to an end buyer, I mean, why not just buy it and flip it? I mean, flipping is something that many real estate investors do. So if it's such a wonderful deal for the end buyer who's going to flip it, it's probably a decent deal for you. So buy it and flip it, or double close. This is where an investor will buy a property and pretty much simultaneously sell it within a very close period of time to an end buyer. But there's a close where you become the buyer, you become the owner, and then a second contract where you're selling the property. But we see those happen, you know, just back to back. And short-term transactional lending, you could find a lender who is going to give you a short-term loan for maybe daily, weekly, or monthly basis. I know they can be kind of expensive, but this is an alternative. You could do subject to financing. Rather than paying for the property, you could take over a seller's mortgage payments. There are some distinct pros and cons to doing that. Probably the largest con is that there are acceleration provisions in most mortgage and deed of trust documents that don't permit this, but people are still doing them. Wraparound mortgages. This is where you could take over the seller's mortgage and offer a second to be owner financed up to the amount of the remaining purchase price. I'm drafting every week extensive numbers of leases with options to purchase, where you could become a tenant and you have an option to purchase from the seller. Contracts for deed. This is where you're making payments over a period of time but not becoming the owner. So you will be the buyer over time. Or, you know, hey, if you don't want the risks of wholesaling, which is understandable, you could go and become a real estate agent. You can earn a commission of up to 3% on, seems to be 3% is about the industry standard on every sale. You could educate yourself as to the best practices in the state. You can list real estate openly and honestly as a broker. But if you are an agent and you are also wholesaling, which is legal, you do need to disclose that you are an agent and you are acting as a principal in these contracts, as we went through before. And finally, before we get to questions, just a few of the common myths that I'm seeing on the internet about wholesaling. Probably the most common myth that we're seeing is that the law doesn't apply to me because I'm not a realtor. That is false. The law applies to every person conducting business in the state of both Missouri and Kansas. This statement saying, like, I won't be found as an unlicensed agent because I'm not going to get a license. I mean, it's kind of akin to saying that you can perform surgery and you won't be reprimanded because you didn't go to medical school and get a medical license. It's just not true. So your presence in the state of Missouri or Kansas means that you have to comply with the state's laws. Wholesalers can't get around the laws. So sorry to tell you that, but it's true. A common myth that we do see is that wholesaling is unethical. A lot of agents and brokers believe that to be true. I do not believe that to be true. It is not unethical as long as the wholesaler is being honest and transparent and providing sufficient disclosures. The next myth I see is that wholesaling is illegal. That is also false. If done with transparency and disclosures, I think that it is legal. Now, we're seeing in cases we only have case law that's coming down from really bad acting wholesalers that have not been honest and transparent. So I think it is legal. It is legal, not illegal, as long as it's done with transparency and disclosure. I'm hearing more frequently that investors are coming to me and saying contracts are not assignable. The title company is not allowing me to assign a contract. That is false. Obviously, the underwriter of that title company hasn't spoken with me, but contracts are assignable unless the contract states otherwise. And you need to address this in your contract. If your contract says the buyer and or assigns and then makes the disclosure that you're going to assign the contract, we've been assigning contracts in real estate law, since the beginning of time. So I think that is false. That's pretty much a myth. And I can't hammer this through enough. A common myth that I'm hearing is that, I went to a seminar and I downloaded this contract from the internet and these advertisement packages from the internet that I bought as some sort of national seminar. And that isn't that sufficient to protect me? No, that's false. I really would like people to stop downloading or borrowing contracts from their friends in other states. There are state-specific laws, and you need to follow the laws of the state where you're conducting business. And it really does not cost that much upfront, in my opinion, to hire an attorney. Many of us that are doing a lot of wholesaling investment work read a lot of these contracts. Not that I've seen every contract out there, but I have seen a lot of contracts. So for an investment as small as $250 to $350, you can feel confident in the contracts that you're using if you feel like the ones you're using, were purchased or downloaded from some seminar that's not state specific. And finally, questions and answers. What can I answer for you?
Okay, well, I will start at the top. I think we have answered some of these questions as we went through. One question was at the beginning, earnest money was mentioned earlier. Is this not one level up of accountability to perform as outlined in the contract for purchase? Most sellers are under the impression that the one they're dealing with is the buyer. So I think he's basically asking more about the earnest money. So you covered that. You pay one earnest money to the seller and you get another earnest money from your buyer, correct? That's
how I structure these. If I'm involved in the transaction, generally the wholesaler / buyer in the underlying contract, we'll post a small earnest money deposit. I see as little as $5 to $100. The point of wholesaling is to try and minimize your risk, and you don't want to be out, $2,000, $5,000, $10,000 in earnest money. On the second assignment contract, we also obtain a second earnest money deposit that kind of covers the risk on the end buyer's contract and the assignment. But you have to, a common myth I'm hearing from people is, I don't have to put down any earnest money, which I would disagree. An essential element to just any basic contract is consideration, and that earnest money deposit is considered the consideration.
And would you, on the assignment contract, have some sort of non-refundability clause for that earnest money? So after their inspection period, the earnest money is no longer refundable?
Correct.
Okay.
Correct. During the inspection period, I think it's only fair that the buyer or the end buyer can back out for any reason during the inspection contingency period. That's the time in which the wholesaler or the end buyer has the opportunity to determine whether or not they're going to close. And after that point in time, yes, the earnest money is non-refundable.
Okay. Next question. Since the wholesaler never actually intends to buy the property, wouldn't an option, a unilateral purchase option contract, be better?
Well, yeah. Yes and no. I mean, as I said, a lease with an option to purchase it's an alternative to wholesaling. When asked to talk today and educate people on wholesaling, the kind of essence of my whole presentation is to talk about wholesaling, not necessarily the alternatives to wholesaling. Yes, an option contract is a strong alternative. So if you don't want the risks of wholesaling, we're putting people in option agreements all the time. Generally, option agreements are structured to be much more long-term,
right,
where we're giving people an opportunity to come in and live someplace with the option to purchase over a significant period of time. It's a form of owner financing. Most sellers in wholesale transactions are motivated to get out quickly, and most wholesalers are anxious to turn a profit quickly. So option agreements are an alternative, but generally they're structured to be much more long-term.
Okay. And this is from our group leaders. This is from all of us that run Facebook groups and other groups. How much danger would the leaders of those of us running these groups be for allowing our wholesalers to post properties they don't own?
Well, first of all, I would say that just by virtue of running a website where you're not responsible for the person or for the content of the post, you just allow members or people from the public to post. There has to be an intent with any type of criminal investigation. And so I think just by running some sort of website or web page, I don't think that there's any liability to you allowing people from the public to post advertisements. I guess I could dream up situations in which the Attorney General could say that perhaps you are acquiescing to false and misleading statements, but I don't think if you just, you're not onesie-twosie reviewing these, correct? You're just allowing people to post deals. Am I correct?
Although we do, all of us, not all of us, but a lot of the groups do post a rule that if you're posting properties, the conditions to which we allow them to post properties. Now, do we go investigate to see if they're following the rules? Well, we can't really do that, but we do post.
Yeah, I think there's a minimal risk, in my legal opinion, to just running some sort of website and allowing anyone to post on it from your membership. I think the liability is going to be with the wholesaler who's posting the ad, that's misleading.
All right. And then a lot of our groups were all investors, so we understand what wholesaling is. At least we would hope that everybody on a real estate investor website knows what that is, although we've been getting a lot more of the public joining our groups because they're looking for properties to buy for themselves. So.
Right. Yeah, inventory's a little lean these days, so I know people are searching high and low.
Yep. And one question, I did answer this, but the question was, can you wholesale and still have a real estate license? And my answer was, yes, you could do that, because I do that as well. But I've been finding that a lot of the brokers across the city are saying, no, you can't do that if you're an agent at my.
Well, again, wholesaling is considered to be not a high-risk investment, but a risk. As you've seen, we've outlined the risks today. And brokers, they're looking after themselves and their own industry, and they don't necessarily want the liabilities. I think that if you were 100% transparent, sat down with the broker, showed them the disclosures, and asked, for a second opinion, because you are so transparent that a broker might reconsider it. In the alternative, there are a lot of brokers out there.
Yeah.
And after a few years as an agent, it's not terribly difficult to become a broker.
Correct. And I think where part of it's coming from, speaking as a broker, we are a very small company at my brokerage, so it's just us. And when we go and apply for our errors and omissions insurance every year, one of the questions is, how much percentage of your transactions are the agent a principal in? And basically, we're told that any transaction that we're a principal in is not covered by our E&O insurance. And I think that a lot of brokers are having to answer that and might be having problems getting E&O insurance. That's why they're saying no.
Yeah, that's a distinct possibility.
Next question.
And if you ever get sued, your broker's going to get sued. So if you are an agent and you get sued as a principal or an agent, as a real estate attorney, I'm always going to sue the brokerage entity as well, because I want the insurance or the money.
Right. And that's one of the things that they may be facing, is they actually read the rules with their E&O and say, oh, I can't have people wholesaling under my E&O insurance. So next question, what is the process for obtaining sample contracts or developing contracts for personal use?
Well, if you hire me, or clients who have hired me in the past, I usually give them a couple of opportunities. I say, if you're already wholesaling and you're already using documents that kind of conform to your business practices, send them to me so that I can incorporate your current business practices into a contract that I consider to be compliant. In the alternative, I can just, I've done so many that I can put together a contract for you. Or you can also take the risk of, as you attend wholesaling seminars, using those contracts. I don't think it's the best idea. I think you should go to a Missouri or a Kansas attorney and say, fix this. Because I've done so much, again, you're looking at about a $250 to $300, $350 investment to ensure that you have state compliant forms.
And that's way cheaper than buying the course.
Yeah. Well, or, today for free, you heard me kind of go through a sample contract. I know you can re-listen to this. You can probably figure out just from the presentation today, what are the weaknesses. And if you don't want to invest the $250 to $350, you can piecemeal hire an attorney and just say, only draft for me these 3 provisions. I think I'm good otherwise. I personally think, considering the risk of wholesaling, it's worth the investment, but that would be the process.
Okay. And I'm not sure on this question, but I'm going to say if you're out there and as a wholesaler, you are buying a pre-foreclosure, so the property is in foreclosure, or, possibly a short sale, is there anything we need to be putting in our contracts and disclosures as to that fact?
So I'm going to speak to Missouri law first. all the contracts have a disclosure by the seller. Again, the buyer, well, during the due diligence period, you better figure these things out and the timeline on them. But as a seller, they have to tell you. So it's not really the wholesaler's responsibility to disclose the presence of a foreclosure as much as it is the seller's. However, if you do know that, you're on a pretty tight timeline. So when someone says the property is, quote, in foreclosure, that could mean a number of things. That means maybe there's been a letter sent, but there's not a sale date yet. If for some reason there is a sale date set, you must close prior to that sale date and time. And you're going to have to pay the entire amount unless it's going to be a short sale, which is a completely different negotiation. In Kansas, a foreclosure is a judicial process, which means that petition is acting like a Liz Pens on the property, and you're going to have additional problems. I would probably advise a wholesaler who's getting involved in a Kansas foreclosure to consider buying or brokering essentially the contract to an end buyer for the right to redeem the property from the seller. So I don't know that the transaction would necessarily look anything like a standard wholesale contract. But in Missouri, no, the buyer doesn't have any duty to disclose a foreclosure, the seller does. Okay. And that's why under that seller's disclosure section, I kind of went through all the elements that I make the seller disclose, or, you know, it's definitely good talking points.
And I know from doing short sales that if you are buying the property as a short sale, somewhere in the agreement where the bank approves it, it says that this contract can't be assigned in every short sale I've been a party to. So, and that gets attached to the contract from the bank.
And the reason for that is the bank, as a part of the wholesale application, or I'm sorry, as part of the short sale application, is looking at the likelihood that the buyer can close and will close in determining whether they will allow the property to be short saled. You know, they don't want to mess around and just have 50 applications and then it assigns to somebody else and they don't have the ability to close. So in a short sale application, you're giving the bank your financial situation. And that's why they don't want them assigned.
Okay. And let's see. Michelle is asking, on the earnest money or the consideration, should that always go to the title company on both sides of the transaction? Or should we
that's the most legitimate way to do it, yes.
Okay. All right, we're going to go down. And Judy is asking, what's a fair wholesale profit? What's legal, fair, and fully disclosed?
So this kind of goes to the heart of what is wholesaling. The profit is what the market will give you. You know, you can make as much money on any transaction as you can make. Welcome to America. But you can't do so in a deceitful way. So if you're taking advantage of a seller who's disabled or aged, or you're unduly pressuring them, it kind of goes to the ethics of, fair dealings. But I can definitely tell you just like all of real estate law, there's nothing out there that says a profit is too high. If you fully and transparently conducted the transaction, you can make as much money as you want and as you can.
And if you feel uncomfortable, then you figure out how to find a transaction funder and buy the house and then resell it. And when you do it that way, you also have much more capability of making more money because you can market it across a broader spectrum, doing a lot more things because you own the property.
Absolutely.
Okay. Any more questions? Type in the chat box. Although I have somebody here that might not be able to. Let's see what Georgia, let's see. Let's unmute her. Okay, I can't, so never mind. I was going to try and unmute this person, but it doesn't work. All right. Oh, that looks like all of my questions. If we have any other questions that we've missed, be sure and email them to me, and I will get them to Julie so we can get a little bit further information on them. I thank Julie for taking time out of her day to teach us, and hopefully we will have fewer letters from the real estate commissions coming out. I don't know if that'll be the case, but we're hopefully, at least those of us on the call, will be more educated and not get any letters.
Absolutely. Well, thanks for having me.
I have a lot of thanks from everybody coming in on the chat, Julie, so you are very, very well appreciated. I will be transcribing. It takes a couple hours to convert this recording to something that I can resend, but I will be sharing out the recording and Julie's PowerPoint, so you have your checklists later this evening.
Great, and I look forward to joining you in April. We're going to be working through some of the hottest topics for landlords right now, and I know we're, as an industry, a little upset, so I'm going to be kind of myth-busting through landlord-tenant law in April.
We're looking forward to that. So I'm going to go ahead and end the call so we can all go about our day. And I think Julie has some classes to teach this afternoon, so I'm sure you need to get to those.
Yeah, absolutely. Thank you. Bye-bye.
All righty. Bye-bye.